Welcome to Third Fridays, the monthly legal talk show from LOIS LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome to the August 2022 edition of the Third Fridays podcast. We've got a very special edition this month because it always culminates in the end of a 4 or 5 month long mock trial program here at LOIS Law Firm. So this podcast will be dedicated to the finalists of this year's competition. And we're going to start with our paralegal finalists. Before we do that, I'd like to introduce my first guest, champion of the attorney competition last year, Addison O'Donnell. Welcome back to the show.
Thanks for having me. I'm glad to be on this side of the table this year.
You had a rough go last year after you won.
Well, I mean, it was challenging. It's tough. You know, my adversaries were LOIS attorneys, and they're aggressive, they're creative, and they put up a good fight. So I'm glad to be where I'm at.
Right. Good to be on this side. On the other side of the table, we have Melissa Gannon, Georgina Reid, and Cara Malanowski. Welcome to the show, guys.
Thank you.
So I haven't told you anything about what this recording is going to be like, right?
No.
Just super excited about how everything's going to go, right? So let's start off with trivia. Okay, so trivia is going to encompass the entire program, and there are a couple of different ways that you can score points. Okay, so there are 3 categories of questions. A question can either be worth 1 point, 3 points, or 5 points. If you pick any value question, obviously a 5-point question will be harder than a 1-point question. If you get it right, you'll get the points. If you don't get it right, you won't get any negative points, but it will give the other 2 finalists an opportunity to steal those points. Okay? Now, if you try to steal those points and you get it wrong, then you'll get negative points. Okay? So that's one way you can get points or lose points. The second opportunity to get points is by requesting an all play. So if you ever played Pictionary, where you draw against your competitors for the same thing, what you could do is say, I want this to be an all play. They're only eligible for 3-point questions and 5-point questions. So what that means is the question will be given to everybody, and whoever gets it right the quickest will get double the amount of points that the question is worth. If it's someone else that joined in on the question and got it right, they will just get the value of the points. You'll each get 2 choices, right? So you might go, I want to do a 5-point question and a 1-point question. You might say, I want to do a 5-point question and a 5-point question. But you'll each get 2 rounds to pick a point value question. Feel good about it? I guess that's, subjective. But at least you understand what we're doing here. Does anyone want to go first?
Do we get a point for going first?
No, you don't. But everyone's going to go, so.
And by the way, Pictionary is not a registered trademark of LOIS Law Firm.
I'll go first.
Okay. All right, so Cara's going to go first. Would you like a 1-point, 3-point, or 5-point question?
3-point.
All right, and would you like to make it an all play?
No.
Okay, so it's a solo question. Do you want to pick one, Addison?
I'm thinking this one. Yeah.
Okay.
All right. Cara.
Addison.
Can an appeal be made following a finding of prima facie medical evidence? Please explain.
Yes. If there's a reasonable basis, whether the doctor, if it was, it's at the judge's discretion. However, I would say that we can always file an appeal as long as we have a reasonable ground to do so, such as if we don't think that the doctor sufficiently showed that there was causal relationship between the claimant's employment and the work-related injury, if he didn't have a history of what happened, if we have any indication of priors, anything of the like.
I'd give that 1.5. Maybe like half of that correctly. So I'll give you a 1.5 for that one. Would anyone like to steal the other 1.5 and risk negative value? We don't have to. We can move to the
It's
next
only
round.
1.5. We'll move forward.
All right. All right.
What was I missing?
So the answer that, well, the first part was yes, you can make an appeal of a PFME finding as long as you are appealing the standard that PFME is, right? It's generally seen as an interlocutory decision, but if you're appealing, for example, that a COVID-19 positive test is PFME because it's a medical report referencing an injury, if we argue that that standard hasn't been met by the particular medical record, then you can file an appeal.
Even though it's interlocutory.
Right.
So I didn't say interlocutory.
You needed the I word. You needed the I word.
All right. Anybody want to go second?
I'll go.
Okay. Would you like a 1, 3, or a 5?
I'll go 3.
3-point question. Solo, all play.
Solo.
Okay, the question is, name one of the 6 claimants whose case did not go to trial, whose initials were not BH. Remember, there were like 7 claimants, right? Only 1 claimant went to trial. Can you remember the name of one of the others? It's from the Addison O'Donnell Dictionary of Fake Names.
Many, many pages of that.
I want to say Jim Marzola.
That is correct.
That is correct.
Jim Marzola is correct. So Melissa has 3 points. Good job. Okay, Georgina, your first round question. What type of point value would you be going for?
So many choices. I'll take a 3.
Okay, everyone's going for 3.
Jeez.
Would we like to make it an all play or just go solo? Solo. I'm wondering if all play was a good idea as a thing, if no one wants to do it.
Yet.
Yet. Good call, Georgina.
Sweet.
Georgina.
Yeah.
Name 2 people of the opposite competition group who have secured a first place finish in any prompt this year.
So the opposite competition group would be the attorneys, right? How many, can you name 2 people that have won a prompt?
I believe. I want to say, if I get this wrong, if Kyung Jae and Dean.
That is correct. Kyung Jae won 2, actually. Dean won 1, and Marcos won the other. So 3 points for you. All right, Cara, we're going back to you for round 2.
Oh, 5 all play.
Oh, 5?
Jesus Christ, Cara, do you have a grudge?
It was almost like, just like
all or nothing.
say something and then boom.
Gosh.
You know I like a challenge, Christian.
Right.
Even if it's against
It is.
myself.
This one is a challenge. I mean, the 5-point questions are hard, so everybody's involved, and you can write your answer down if you want to. Okay. Now, this question is going to involve a knowledge of how the prompts have ended, right? So if you can figure out like the results of each one and how it goes. It's a tough question. Name the person who finished 4th in both competition groups. So the reason why it's tough is it hasn't been in any email, right? You just have to try and think about which attorney and paralegal has been doing just good enough, but not good enough to make it to the finals where you lovely ladies are sitting right now.
They're still good, though.
Oh, yeah. They're
It
great.
just seems like a wait, do we lose questions on this one if we get it wrong?
No. But if you get it, you get 10 points because you called an all play.
What
So
if we get 1 right and 1 wrong?
then I guess it would be like half. Like
Okay. Okay. I'll take that. I'll take
All
that.
right, so write your answers down and like maybe like show it so like you don't like just 1 attorney and 1 paralegal. Yeah, if you're Are we now thinking that the all play is backfiring?
No. Can't be more straightforward than that.
Got 5 more seconds. 4, 3, 2, 1. Okay, pick one.
I don't know what paralegals work.
You better pick one. You better pick one right now. Who are they?
I don't know. I don't know who did this.
Name a paralegal.
We're going to consider it a non-answer.
That's fine.
All right?
Okay.
Non-answer.
Okay. What do you guys have?
I have Pre and Dean.
Pre and Dean.
I have
You got
Nathalie and Pre.
Natalie and Pre. Well, neither of those answers are correct. So nobody gets points. But that was.
I had an attorney answer.
Oh, you did?
Yeah.
Oh, now.
Let me
Oh.
let me show it. Let me see it. Misha's also incorrect.
Okay.
But maybe that just goes to show that it was close.
This is tough.
It's a 5-point question. Person who finished 4th in each group was Marco Sias
That was my second
and
guess.
Reina Villar. So yeah, that's a tough one. Okay, so Cara's questions are done. We'll go to Melissa again for your second round question. You can still steal though.
Yeah.
We'll go 3.
3 again.
Melissa.
Addison.
What is the legal standard for medical causal relationship?
Give me a second. It has to occur within scope of employment. There has to be an injury, and it has to occur with. No, I said scope of employment. I'm just going to keep it at that.
It was like thinking of like rule of 3. Let me just throw 3 things
Let me
out
go
there.
3 things.
Those are true things, but it's not correct. Would anybody like to steal that answer?
How much is this?
It's 3 points. If you guess, you can get 3 points, but if you guess and he gets it wrong, you lose 3 points.
No.
No?
So
keep my
none of
1.5.
what she said was the legal standard.
She was saying correct things,
Yes.
but it wasn't the legal standard of how that issue is determined.
What's the question?
What is the legal standard for medical causal relationship? So we talked about it actually in the deposition prompt and also at the trial. You don't have to guess, by the way. You don't have to try to steal.
Okay, no.
All right. So Georgina, it's your last question. You want to go 1,
Wait, what was
3?
the answer?
Well, we should.
Yes.
Yeah, we should give the answer, right?
So
that would be
we would have accepted anything around this basis, but sufficient probability as to the cause of the injury supported by a rational basis.
That was
Right.
just.
Cara's given me
I
the
just
scrunchy
wasn't-
face.
I wasn't gonna risk my 1.5 points,
You would have.
but I would have gotten 3.
okay.
Could've,
So
would've, should've.
do we? I don't even know if we have any 3-point question. Oh, we have 1 3-point question available. Do we?
Yeah, we have one left.
Okay.
That's fine.
If you want to do that, I just assume everyone's doing 3. But if you want to do 1 or 5, actually no, Cara did a 5-point.
Yeah. Okay, so I have a 3, and I can do all or.
Yeah, you can choose to bring them in and double your points if you get it right, or
So
Okay,
do
let's
it by
double.
yourself.
Let's double the points.
All right. So we can all play for 3.
Yes.
So it's worth 6 points for you, Georgina. 3 points for you guys.
Okay.
All right. According to the incident report, approximately how many employees were injured as a result of what occurred on the day in question? So whoever gets it closest to the number will get the correct answer. So how many employees? You probably want to write it down.
Are we allowed to look at anything?
What?
Can we look at anything?
No.
No, you
No.
can't look at it. Like, I have the instant
I
report
have
right
the
here.
answer.
A for effort, Melissa.
Ooh.
Law school would have been a lot easier under that rationale.
All right, just like
Can
memorization.
I-
Like
can I
make,
just-
make everything the bar exam.
Is
Oh
this
my
Price
Lord.
is Right rules the closest without going?
No, let's just be closest. Are we all good?
Yes.
All right.
What's the answer?
Well, show what you wrote. Show what you wrote.
I said 40 to 50, so I think around.
40 to 50. I'm going to make you pick a number between 40 to 50 because then that means you get the whole range, right? Pick like an actual number.
50?
50.
I said 50.
50.
I said 42.
The answer is 49.
Holy crap. Okay.
I actually wasn't considering this possibility where like Georgina did all play, gets it right, but Melissa also got it right.
We could have a standoff.
Underdogs
We could
win.
do a standoff question.
Do you want to do that?
Yeah,
right.
absolutely.
All right. So whoever gets this question right would be either Georgina gets 6 or Melissa gets 3 points.
Oh, gosh. Georgina,
Yes.
Melissa. What was the name of the employer witness at trial? Write it down.
Not the person who played the
Not
witness.
the person who
we
played
all
the
know
witness.
and love him.
The role.
But the name of the
Employer.
the name of the employer witness, like the supervisor
Of the employer.
I have one question. Was it a name that was already stated before?
like before
Like,
I don't know.
I mean his name was mentioned in the
Podcast?
In the trial.
in the trial. That's not going to tell you whether it was in the podcast.
The employer witness.
Employer witness name. Yeah.
All right.
This is like stone cold. I got it.
Okay. Let's write something down. Okay.
All right.
What do you
Let's
got?
see your answers. What do we got here?
Jim Marzola.
It's Jim Marzola.
He's Jim
Jim
Marzola.
Marzola.
So
All right.
Melissa.
Another. That's why I would ask, because you.
Right, because she
Same
said
question
it. No, I know
twice. Yeah.
why. Yeah. Okay. All right. So that does it for trivia. We're gonna be right back to come and talk about our next portion of the podcast, which will be about the trial and what happened thereafter. And we're back. So we just gave the finalists some materials to work with. What did you guys see? Like, what did you guys describe what you just saw? It might be hard because it's Addison O'Donnell and all his theatrical glory. But what did you guys see there?
The judge putting his decision on the record and providing the basis for his decision and opinion. And then obviously claimant's counsel objecting to all of the findings to set up for an appeal. Another tomfoolery going on.
Tomfoolery.
Harry Potter looks very different than I remember.
So how do we go about analyzing that for anybody else who isn't in the room, right? How would we describe what happened? Can we boil it down to a few sentences, any themes that we can talk about?
I mean, there was summary of the direct and cross of the claimant and the employer witness, and pointing out maybe inconsistencies or things that didn't make sense, and then a summary of the summations from the claimant and the carrier. Again, pointing out inconsistencies or things that just maybe were important, and then a finding based on all of those summaries.
Okay, yeah. I mean, I'd say that's a pretty good rendition of it. So, what happened after that? The claimant appealed. The claimant appealed that. And what we want to discuss today is what would the claimant argue and how would the defense rebut it? No one's taking a particular role, so it's just a conversation. But any of those topics, I guess there's two, right? Like, what would the claimant argue on appeal? And what would the defense say to rebut the claimant's appeal? Anybody can go. There's no...
I mean, I know one of the exceptions that they noted was that the claimant provided evidence of an accident happening and medical records to support it, and stated that the carrier didn't prove anything to the contrary on the trial level. However, from the records that we have, I know there was an employer witness that was produced. The carrier would be arguing or rebutting, I guess, their claims that their claimant was more credible in testifying to the fact that an accident happened and that the employer witness was incredible in the statements. And then when it comes to the medical records, the claimant would be arguing that doctor found within a reasonable degree of medical certainty that the claimant's injuries are related to the accident of record. However, we know that the doctors are going based off of what the claimant's reporting. So in our rebuttal, we'd be arguing that the law judge already found that the claimant was incredible in their reporting, therefore the doctor's reports are incredible in finding a causal relationship.
Okay, yeah, so that, we're talking about like whether the accident happened, who was more credible in testifying to that. What would a board panel review to make that determination? What kind of key points would they look into to determine if the claimant's appeal is correct or the claimant's appeal has merit?
The incident report, I would say. The incident report?
Okay.
I would say, because it's documentation that not only does the manager, I think because, the amount of people that was involved in the accident, you can't say that 49 people are lying. And then, if I'm not mistaken, that one person saw the explosion, who was driving on the highway and then crashed into the building and died. So you can't say that didn't happen because a person is dead, even though they didn't work there. Because of the explosion that happened, a person is dead. So whether it was one explosion or two explosions, there's also going to be a police report of why that person died. So you can also, I think the board will also look at that too, even though it's not directly related to the explosion in the building, it was a cause of it. So I feel like those are the things that they're going to look at, as well as, the other 40-something people who were in that accident, they can also bring them in for testimony as well. So that's
not a bad idea. Why do you think that didn't happen, right, from any of the claimants' counsel groups at the trial? Like, request to bring different people in or a police report or anything like that?
I mean, based on my experience, lining up employer witnesses can be a pain. You have people that have a fear of retaliation from their employer. If they're still employed, want to still be employed. Also, based off of the scope of the alleged accident in this case, you can assume that other people are also hurt. They might be filing their own claims. So there's kind of it makes it almost impossible to coordinate everyone and their own claims and their own injuries. And then, you're trying to just deal with the people who you find the most credible when you're presenting an employer witness as well. So if you only need one, why are you going to waste the time of the courts and yourself and attorney, paralegal time, all of that, when you think that one will get the job done?
And I do want to push back. The employer witness that was presented, there was one. The claimant was the only person who testified on her own behalf. And so really, why didn't the claimant bring another witness in? Maybe you don't need 49 people, right? But that's the red herring. That's the scapegoat. You don't need all 49 people to corroborate. You just need more than one. So how would you make that argument?
Which is also a good point too, because I like that idea, right? Like, how could 49 people be not telling the truth? But if we think about the possibility that they would be telling the truth if they testified, why is only one person, right?
Maybe only that person knows that they can do, that they have the right to that.
It's
maybe
possible, yeah.
No one let them know that, hey, you can file a claim, like this happened, and also the building broke down, so they don't even know if they're not going to work. If I'm not wrong, like the factory broke down. So they would have to actually get a notice inside of the mail stating that, hey, there's this thing going on, you should be involved. So I think that's might be why they didn't know, or they weren't brought in.
I mean, claimant's counsel also is lazy in that they just assume everything's going to be in their favor. The burden is on, in this case, it's presumed that an unwitnessed accident is to have happened.
Was this unwitnessed?
No, but I was just saying that.
Interesting.
There was an employer witness, so.
Well, if you guys were claimants counsel, you wouldn't be lazy.
No, absolutely not. No, this would have been established, temp total awards, permanent total disability.
I feel like when there's like an accident where there's multiple things going on, multiple people are injured, the more people you have, the more risk there is of stories not lining up, people not saying things that add up. And you're putting a risk of not having anything established or anything, You don't want to go in there and have two different people saying two different stories. better safe with one person who is closest to the claimant.
I think that's a pretty good claimant-oriented answer. But like, if I have 49, right, the ones that don't corroborate my story, like, you stay at home, right? If I get, right, like what Az is saying, is bring in one person, and now the judge is saying, well, two people came to corroborate this, as opposed to one person who's filing a claim that has a self-interest in giving this testimony. It makes it easier for a judge to say, well, if your own reports are saying 49 people are involved and you didn't call anybody, I think it makes it easier for the judge to look at the employer side and say, where are the other 48? Okay. What about causal relationship, right? We went over in trivia, what the legal standard is, but based on what happened in the deposition prompt and like arguments at trial, do you guys believe that the claimant has a good argument for saying that her injuries were related to this accident?
I think for certain sites, yes.
Yeah.
I think for like the site, I don't think so. I mean, there was so much evidence that there were prior treatments on medication for what she was alleging, years before the accident. I think that would be something that wouldn't have causal relationship. I think it's harder to like, I don't know how to say this, but it's harder to prove that like the back injury didn't happen on the work accident. Like if there's injury, if there's pain, if there's limited range of motion, and it gets established, the case goes on and there's PFME for the back, it's harder to disprove that.
Especially if you don't have anything to the contrary, any other possible cause of that. Like it'd be one thing if she was in an accident, a car accident 2 years prior, was even receiving chiropractic treatments prior to kind of say that there's another possible cause for it. But if there's no other way to kind of channel the doctor's opinion on causal relationship and they only have the one incident to look at, then it's more likely they're going to find that that's the cause of the complaints.
That raises a good point because, Addison, you see this a lot too, where a claimant's attorney will say this accident resulted in a claim that should be established: neck, back, shoulders, knees, hands, fingers, feet, toes, and it almost adds to the lack of credibility of it when you say your whole entire body was injured. Whereas Melissa's saying, well, if one of the body parts is more likely to be established than others, did the claimant bring forth a less credible claim because they're adding this psychological component without credible medical?
The assumption is that there is an injury, but where did the injury come from, right? And that's tough because sometimes how do you disprove that there was no injury? It's a very tough thing to prove. Sometimes it's impossible, but with enough medical acumen and skill, you can look in and say, hey, degenerative, it says degenerative osteoarthritic, right? There are certain words, right, chronic, that imply that it wasn't something like an accident.
I mean, it's also an opportunity to kind of take a shot at the claimant's credibility and have them testify specifically, how did you get hurt? That's something that you need to be strong at the inception of the claim and make sure that we're getting testimony of okay, you're alleging that you injured your left shoulder. How exactly did you fall to hit your left shoulder? And even if the claimant says, I don't remember, it was this big traumatic event and stuff, it's something that you put in summations to just point out that the claimant's incredible and the basis for finding that causal relationship is insufficient.
So I've got a lightning round question I want to ask every single person here.
I was not prepared for this, so I'm excited.
You must give an answer and you must give a rationale. What about notice? Was there proper notice? Explain why. I'm going to start with Melissa.
Does that mean that they can should we have them write it down?
No, I want to hear it on the spot. Make your argument on the spot.
Okay. All right.
On the spot.
Okay. If I'm remembering correctly, the accident occurred on February 2nd, 2022. Notice was given February 30th. No. February 30th? I'm going to say February 28th, which is over the notice requirement. So no, notice was not given.
All right. Georgina, was there notice?
I would say there was a notice, but was it properly done? No, but it was done. So I feel like that needs to be taken into
How was it
consideration.
improper?
Well, the date was incorrect on the accident sheet, but I interpret it as the person at the last day of the month instead of saying, the 30th day of February.
I don't remember the exact dates to argue for the notice issue, but the issue with notice that we would argue is whether or not it prejudices the carrier in this case. So whether or not notice is found, we could still argue that it prejudices the carrier if there wasn't a proper time to investigate it, especially if it's a catastrophic event. We want to be there right away. If we didn't get some type of investigator on the scene until 30 days later because notice took some time. You have caution tape up, you have people cleaning things up, you have whatever hazardous material people in there cleaning things up.
It was funny, like the same question to three people. I thought I would get like bits and pieces of the answers together, but it was three different answers.
And I'm extremely impressed at each answer.
Right. So you can argue that notice was untimely because, February 30th is not a real date, right? So
30
it's like
days
September. Saying that we can't determine when notice was given, right? But if you believe that February 30th was February 3rd, right? Maybe there's a typo there, right? Like notice would have to be within 30 calendar days to be timely, right? And Georgina, you were saying something about how like notice was given, but it wasn't the right way. Well, if the employer witness was there and knows that something happened, right? Does the claimant still have to prove it? No, right? Because that's actually one of the exceptions. If the employer has actual or constructive knowledge of the accident occurring, then the claimant doesn't actually have to provide written notice to the employer. That makes sense, right? You're there, you saw it, it happened. And then to your point, right? Yeah, it's like almost like the system works because Cara is saying like, yeah, well, we would argue prejudice. And I was like, oh yeah, that's right. The system's working. We're thinking defense again, right?
Right.
Like,
I know.
And no, I'm actually surprised that we got three different answers. When you said everyone was going to answer, I was like, they're just going to piggyback off each other's
I wouldn't
answers.
allow that. If someone copy and pasted, I would have been like, nope.
Right,
No,
right.
moving on.
Okay, final thing, guys. If you were the board panel and the claimant appealed, would the claimant succeed? Just write yes or no on your paper, and we'll ask you to give 1 to 2 sentences why you think that's correct. You don't have to write the sentence down, just like the yes or no, and then when we come to you, does anyone want to go first?
I can go first.
All right. Melissa, would the claimant succeed on this appeal?
Wrote no.
You wrote no.
No.
Why?
I think giving the full prompt and everything that went on based on inconsistent reporting from the claimant, unreliable witness testimony, I think there's too many, I won't say red flags, but red flags that don't line up and don't make sense. And I think the board would just affirm the decision of the law judge.
Okay.
I said no also, because obviously we have the Addison O'Donnell Appeals Bureau who would pull up case law from the pits of wherever. But I think really the board would rule in the carrier's favor because it was a credibility determination, which essentially comes down to the law judge. I've not seen many instances where it's overturned when it really is a credibility finding. But then also there is a lot of inconsistencies in the record.
Okay. I'm kind of hoping Georgina says yes, the claimant, just to make it interesting. But what did you think?
I had said yes.
Oh, okay. I think it makes it like, okay, we wrote a good prompt.
Yes.
Like, like one person thought it should win. Why do you think the claimant should succeed here?
I think the claimant will succeed because if it's just the meaning of them getting the medical records, they can just ask for the medical records and go through it. I don't think that's like a big problem. But the fact that the claimant, as well as the manager, the incident report was made and it involves so many people, I feel like they're just going to lightly lean towards that because it's just too many people and someone died. So I feel like saying it's unreliable for us because we're defense, we're going to say it's unreliable. But for the judge, they're going to see about the number of people, how many people were involved, the outside factors, I feel like, and plus the building burnt down. So there's evidence that something happened for that building to not exist anymore. So I feel like that's why.
No, that makes sense. I was like, should I have paused this so like my friendly adversaries that are listening to the podcast don't steal this information? The person that died is probably a big case theory point, right? If I'm making a summation argument for the claimant, I feel like my first sentence would be, Judge, someone died as a result of this accident, right? And that's the thing that, you start to stir up, the real truths of what's going on and really muddy the water. What'd you say?
I said, but that only goes to the accident, not all the other issues.
Good point.
That's a great point.
Good point.
We still don't know about all,
Right.
the causal relationship, the medical issues, the notice issues, all that. So
that's a good point.
It's a staged accident. Maybe the guy who crashed the car, was somewhere else, and the guy got out and just sat in the corner and watched the building burn down.
That's true. Addison was very, very demonstrative about saying that it was staged.
Staged accident, yes.
All right. Well, I think that covers the substantive portion of it. I always like to end on is, how did you guys feel about the program in general? What kind of improvements do you think we could make so that next year's participants do even better than you guys did? Because I do want to thank you guys. You guys put in, months-long effort to really surpass a number of worthy peers. What went right for the program? What didn't go right? What would you like to see next year?
I like that you kind of went in blind to the prompts, but there were instances where I felt like it was too blind.
Give me a little vision.
Like there was no eyes existed.
Right.
Not just removing a blindfold
everywhere, right?
Yeah. So I think just having like a little more guidance as to what to expect, not so much down to like the details, but like even just knowing, are you going to be defense or are you going to be claimants counsel, just helps. I don't even want to say ease people's nerves and stuff, but
I would absolutely say that.
But I wasn't I almost was less nervous going into
because
it
because
I just didn't
you
know.
Didn't know what it could
but
be.
it almost
couldn't that be a benefit though?
But it almost limited. I don't want to say how much I cared, but how much I cared about it. Stuff where it's just I don't know. It's kind of a crapshoot regardless. Whatever happens.
I think if you knew just what you had. Right?
But if I knew I'm defense, would have spent, a little bit more time getting into that mindset before.
Okay. Fair enough. That's a fair point. You guys any feedback?
I would say that definitely is being too blind point was real. But one of the things is I feel like because we're all together talking about things, it's a little bit chaotic.
Right.
Because we're all talking, but some people are defense, some people are not defensive. We're all mixed in together, so there's no train of thought. So I feel like that kind of thing, just location wise, if everyone that's on this side go over there in that room and then come back together,
a physical distance between opposing.
Because it was 45 people in one room talking at the same time.
That's interesting, right?
Yeah. And no one organically came out and said, "Let's move to the other side of the room."
Right, a breakout room.
Because we felt like we were confined there.
Right. Right.
Interesting. Anything for you, Melissa?
I think what I liked the most was cross-examining and direct examination. I think those were the things I felt most comfortable with. I think I agree with Cara with the being blinded. I also think there were a lot of curveballs, major curveballs that threw me off a lot. But I know it threw other people off. So I think there can be curveballs, but maybe not
not too
100 mile per hour curveball on my face.
Like a major league curveball.
Yeah.
All of this is very helpful, and it shows that look, every prompt you're learning something, you're putting yourself in somebody else's shoes, like Cara said. There are a lot of people involved. You noted there's 40 people in one room talking about it. It's a major program here at LOIS, and when it comes to curveballs, I'm sorry. I am Mr. Curveball.
He's the pitcher on the mound.
This is my one thing that I'm passionate about, and it's you learn something from it. You learn from the welt that you get from the curveball. There's no clear winner because everyone's winning. Everyone leaves the room saying, "I have something that I'm taking away from this."
That's a great point, because if you strike out almost in a training environment, right, because you missed the curveball, then probably more likely to hit the curveball in real life, right? And I think that's a really good point. But all of that feedback is really great. I do want to thank you guys again for your efforts. Everybody that is sitting here at this table truly deserves it, and I think today was a great showing of that. What do you think, Addison? Any final words?
I'm very, very excited. You three have risen to the top. I always say that the cream always rises to the top. Right, a good thing can't go unnoticed for too long, and you three have proven that during every prompt. I'm very proud of you.
Thank you. Thank you.
All right, so for Melissa Gannon, Georgina Reid, and Cara Malanowski, and Addison O'Donnell, my name is Christian Cisan. I'm reminding you guys to defend from day one, and we'll be right back with the attorney competition. Okay, and we're back. It's the August 2022 edition of the Third Fridays podcast. I'm back with Addison O'Donnell, last year's mock trial champion. How did the Paralegals do in that earlier session, do you think?
Well, I was very impressed. From beginning to end, these paralegals were professional. They were certainly assertive in their allegations. And if I closed my eyes, or if I didn't know them at all, I could have mistaken them for counsel. Honestly,
I thought they did great. There was a lot of back and forth, and I can only expect that the attorneys will match them with the amount of talent that we have in the room. So let's get to know them. To my right, we have Connor Wetherington, Kyung Jae Han, and Nathalie Thomas. Welcome to the show, guys.
Thanks.
So as I told you guys, there's going to be a trivia round. Explained all the details for purposes of our listeners. Since we already explained it in the first segment, we won't get into it now. So does anyone want to go first?
I'll go first.
All right. Would you like a 1-point question, a 3-point question, or a 5-point question?
A 5-point question.
5-point question. And would you like to all play it?
Yes, I'll play.
Oh, and the balls are in the air. Okay. This is a very different start in the Paralegals. The Paralegals wanted to try and play it safe, right, and see what the questions are. But I like the tactics here. So I'll turn it over to Addison for the first question.
Wow, geez. Okay, everyone needs to have a pen and paper in front of them. You have to be closest to the number, and whoever is closest to the number, we will measure and gauge whether the answer is correct. The question is, how many entrants were there in this year's mock trial program?
The participants?
Yeah, people who were entrants. Entrant implies signed up.
It's a tough one. This is tough.
All right. Kyung Jae, since you chose this,
has everyone written down an answer? We all
yeah, I saw Connor stroke something with the pen over there.
Kind of like a signature.
I know. Could be a scribble.
Last name's too long for a full signature.
So, how many entrants were there in this year's mock trial program? Kyung Jae, what did you write?
20.
20. Okay. Natalie.
39.
26.
26. So, it turns out the answer is 31. And I believe Natalie, right?
Which you said?
What was your
39.
39?
I think Connor's
Oh, no.
closer.
I'm sorry. You are closer.
26.
26. You're right.
26. 31 entrants. Yeah, it's our largest group that we've ever had, which is kind of inspiring for us on this side of the table because it was a voluntary sign-up, and we had a lot of talent across the board, which actually speaks to the skills from these guys on the other side of the table to kind of beat out all those people, right? But yeah, 31 entrants. Connor, you have 5 points added to your score.
Apologies for my math. I'm sorry. I ignored what Connor said.
I'm just bad at math.
All right, so Kyung Jae's question, his first round question is up. Does anybody else want to go second?
I'll go second.
All right. Would you like a 1, 3, or a 5, Natalie?
I'll do a 3.
A 3.
3. Let's see here.
Sure.
Natalie.
I think we should add like an explain why.
Yeah,
after
absolutely.
this one.
Absolutely.
Oh, do you want to make it an all play?
Yeah.
Oh,
okay. All right. We're just,
wow.
no, it's like we do have
Sorry.
some judges and I guess people watching in the audience. This is a first for the podcast. They have people just watching, and they're just cheering on the all play calls.
All
It's so
play.
great.
All play.
Let's do it.
Okay. I'm going to say a statement, and you have to tell me if it's true or false and why.
So it's the best answer is going to get it.
All right. The Section 21 presumptions do not generally apply to witnessed accidents. We should write it down.
Can you repeat that?
Sure. The Section 21 presumptions do not generally apply to witnessed accidents. True or false, and explain why.
You have a good question repetition voice, right? You say the question, and then the second time is for effect. It's very calming.
Thank you. I was meant for radio.
Do you know, actually, I did speak to this before we recorded. I have a friend who listens to the podcast, nothing to do with workers' compensation, and he specifically pointed out an episode that you were on that he just enjoyed your tone. And I was like, so you've been listening to me every single month, and then this is the one you choose to tell me about and talk about Addison.
Friend, I'm humbled by that compliment. Thank you.
All right. Who wants to submit variance? Should we go with Nathalie first?
Yes,
That's her question.
it's a question. Absolutely.
I would say that this statement is true as the Section 21 presumption specifically applies to unwitnessed accidents.
That is correct. Why would that? Why does that presumption exist, or why does that concept exist?
Well, it's an unwitnessed accident, so it gives a little bit more of a flexibility for the claimant to get that presumption that the accident did occur if no one else was there.
Yeah, it's super unfair, but sure. Yeah.
We don't like it. But.
Yeah. Just assume.
You guys also write true.
I wrote true. I also
What else did you want to add, basically?
I think it's the same. I think this question was a slightly tricking question, actually, because presumption is really about, even if it's unwitnessed, the accident is presumed to be happening. And whether witness exists or not is irrelevant to this presumption.
Whether the witness is relevant to the presumption. Okay. I can see where you're going with that. But I guess the presumption's application is based on the witness. So it is a little bit relevant. I'll kind of slight disagreement there. What do you have, Connor?
No, I said true as well. Because, if you have a witness that's there, it's more likely that it happened, right? And it also kind of plays into the issue of notice. It's more of a constructive notice. And even though 21 doesn't necessarily relieve, the presumptions don't necessarily relieve the claimant from making their burden of proof and proving that the accident occurred, it's just more likely that something happened if someone saw it with their own eyes.
Okay. How do we decide the points for this, Addison? Since everyone got it correctly, and it's based on the support that they put for the answer.
I think they all should get 3 points, but Nathalie all played it.
Okay.
And then
So
you
she
received
gets 6. Okay. We'll go with that. All right.
I'm very impressed by that answer. But then again, we're LOIS attorneys, so we should know the minutia of the law that we practice. Well done.
All right. So that leaves us with Connor for his first round question.
I'll go for a 3-point question, but we'll choose to not all play the question.
Getting the ire of the audience, though. Not as fun to watch, but sure, that's a pretty good strategic move. You guys can still steal if he doesn't get it correctly.
All right. So this is just Connor, not
Just
all play. Connor. My former mock trial adversary.
Good times.
Yep. Now I'm on this side of the table.
Brings back memories.
Here's your question. If a law judge cites a case denying your request to cross-examine treating providers because you have not produced contrary medical evidence, how should you respond?
I'm going to object and say that it is our right under 12 NYCRR 300.10b, as that entitles us to cross-examine treating doctors, even if we do not have contrary medical.
The last part is definitely correct. Last part's definitely correct. It's like a slight citation. It's actually 300.10c. But the citation part was going to be a bonus.
That was a bonus, yeah.
The concept is correct. Yep. So you will get 3 points for that question. The idea is, and we parlayed this in the surprise hearing in prompt 2,
Yes.
Where all the paralegals hated me for a month because we had a settlement conference that then turned into an impromptu hearing. And the issue was that you, as the judge, Addison, were denying every request for cross because the employer did not have an IME. Right? So the idea is that it's not that we don't produce contrary medical evidence. It's that if you have non-contrary medical evidence, if we have medical evidence that agrees with the treating doctor, like CR is conceded, then we don't get the cross. So by not producing the IME, we still retain the right to cross-examine the treating doctor. Addison with his fancy case law citations, like, don't let that trip you up.
Brian v. Borg Warner, and I was speechless. I mean, I got to tell you, when you were the one who argued against it in the surprise hearing, and you said that's not what Brian v. Borg Warner stands for, and it was how the turntables, right? I mean, it was great.
All right, so Connor gets another 3 points, so that finishes round 1. I guess we'll go to Kyung Jae to start round 2 questions. 1, 3, or 5.
I came here for fun, so I'll go for 5.
Oh, there we go. Another 5-point question. And are we going solo or
no? All play.
All play again. Oh, the risk takers.
I came here for fun again. So,
do you think that could be saucy? But it would allow you to
unless we.
I think we're gonna eventually get to that.
All right.
So we might as well do it. We might as well do it. Let's do this.
All right. You'll need your pens and paper. When is the deadline for a respondent brief of a third department appellant's brief? When is the deadline for a respondent's brief for a third department appellant brief?
You guys can tell that I didn't write this question, given we're in the room with Addison, the appeals expert.
We have to see how close we are, too.
Right.
The
I'll be the math portion, right? You be the answer portion.
Okay.
Yeah,
All right.
yeah,
Hey, I went to business school too, my friend. We went to 2 different business schools downtown.
Okay. Yes. The overachievers in the room.
All right.
I also went to business school for undergrad.
Oh,
All right.
Throw that out there.
All
Right.
right.
I took AP Cal.
All right, now.
Don't feel the need to compete with this.
Maybe Kyung Jae handles the math.
That's fine. All right. So the question was, when is the deadline for a respondent brief of the third department appellant's brief? Kyung Jae, since you were the one who requested this, what do you have?
I had no idea, so I just wrote 21 days.
21 days.
Interesting. From when?
From the appellant's brief 5. Yeah.
I actually did the same.
21 days?
21 days.
Okay. What do you got?
I put 60 days.
Oh my gosh. It's like my heart. So, it is 30 days from the appellant's brief filing. The respondent is entitled to 2 extensions of an additional 30 days.
So would if someone said 90?
If someone said 90, I'd be like,
would you give it to them?
I probably would have, because that's standard as a matter of course. When you receive the appellant brief, custom dictates a lot of appellate practice. Just to inform all the parties that you're interested, you could still file them in 30 days. But just to tell everybody that you're interested, you respond back with, I would like an additional 30 days. It's more of a customary professional a procedure. It's not mandatory, but it shows that you've been doing it for a little bit. So Connor was close, but in terms of the numeric amount, it would be both Kyung Jae and Nathalie. So I have no idea how we're going to do these points.
Do we do a tiebreaker question? Why don't we ask them a question that we asked the paralegals?
Sure.
You know what? The one that they.
Oh yeah.
Yeah. That
Yes.
one.
All right.
Yeah.
Let's do the tiebreaker question. All right. You have your pens and paper. Here's the tiebreaker. Name the person who finished 4th in both competition groups.
This is a tough question because I didn't give you the standings after the last trial prompt. So it's mostly an assessment of who's been doing well with you guys, but not well enough to make it to the table with you guys.
What, 4th overall?
Yeah, 4th overall in attorneys and paralegals. So who do you believe was 4th overall?
Now, do I get to answer this as well? Or is the tiebreaker?
It's just a tiebreaker between them two. I mean, you can answer for fun if they don't get it, but we won't give you any points.
That's fair.
KJ's got his game face
I
on.
know. Turn the paper over. It's like, no one's looking at my sheet.
Need those elementary school dividers.
Right. The folders, the trapper keepers. Right, that was a throwback.
Wow.
What is Trapper Keeper?
It's a type of folder
Oh my God.
that, you have a regular folder, the slots are in the bottom to put the paper in. It had the slots on the sides.
Oh.
I don't know why they did that.
I called them trapper keepers too.
I thought that's what they were
Is
called.
that what they're called?
I thought so.
All right. Anyway. All right. So it's the tiebreaker. Kyung Jae, since it was your question originally.
I wrote MZ and EDM.
So Marcos
Marcos
and
and
Emily. Okay, Marcos, Science, and Emily to win his polka.
I put Marcos.
And
I thought it was just 4.
yeah, do you want to guess who came in 4th for paralegals? It could be Emily.
Georgina.
Georgina.
I said Marcos and Uma.
Marcos and Uma. So everybody correctly got that Marcos was 4th.
Yeah, that's weird because we never told anyone that.
Yeah.
You just figured.
4th place for paralegals was actually Reina Villar. So Marcos Zayas and Reina Villar, shout out to them because they also did a great job, but not as great as you guys did. So,
What's the 5th?
Well,
I mean, I could
we're not going to
Excel
embarrass
sheet,
people.
but, I was just like, all right. So they both got Marcos in the tiebreaker.
I know. So we have to do another
Oh,
tiebreaker.
jeez.
Another tiebreaker.
I bet.
Yeah.
Yeah.
All right. You have your pens. You have your papers. What was the full name of the claimant in this case?
And if you guys all get it, it's gonna tiebreaker for this one's gonna be spelling. So just so we don't go to another question here. Spent 5 months with this individual. All right. Time's up. Whose question was it? Was it Kyung Jae's again?
It was Kyung Jae's.
I only remember Greg part.
Greg.
Maybe it's not.
Greg?
I put Greg Agnesurek.
I have Greg Agnerinik.
I think Natalie's the closest. I think Natalie's the closest. Greg
Agnuruk.
It's from the Anson O'Donnell reference. Got
Just
it.
for the folks at home, what was the correct spelling of that last name?
Of the last name, Agniruc.
What's the ethnic origin of that? I'm just curious.
We're moving on, everyone. We're moving on.
So Natalie gets those points. It was a 5-point all play. Because Kyung Jae's here to have fun.
I know.
That's exactly what he said.
Exactly.
All right, so Natalie, your second round question.
Alright.
You want to go 1, 3, or 5?
Well, we'll keep it fun. Do 3, but I'll play.
Oh, a 3 all play. Yeah, for sure.
Okay.
That's a good one.
All right. 3 all play. You have your pens, you have your papers. Who can name the most doctors who testified in the deposition prompt? Treating and IME. Last names are fine. You don't need first names.
It's a tough 3-pointer.
I know. I could give a small hint. These names were based on real doctors who we regularly depose, both IME and treating.
That's a great hint. It's a great hint because there's so many doctors too. It doesn't really narrow it down.
Mm-hmm. But I didn't make them up. Not like Greg Ragnarok.
I wonder if maybe people just take a shot with the types of diagnoses that were involved in the case and maybe narrow it down even further.
Mm-hmm.
This is all just banter to make sure that there's no silence while they write down names.
No. We could fill in on ESPN between periods.
All right, we're going to get 5 more seconds. All right, time's up. Does anybody have 6 doctors? Does anybody have 5? 4? Connor thinks he's got 4.
I barely got 1. That's shot in the dark.
All right, so Connor, who are your 4 doctors?
There's Dr. Joel King. There's Dr. Alan De La Chapelle, who's an IME for the sight conditions. Dr. Teresa Habacker, who's also an IME for the orthopedic conditions. I think I might have misspelled her name wrong, and maybe even got it wrong, but there was an IME, peer-reviewed IME, for the inhalation. Honestly, maybe Dr. Spear, but I think that's wrong.
That is wrong, but I think that's enough to take the question if you guys don't have 3. So, all right, that's 3 points for Connor, and we got 1 more question left in the trivia round. It goes to Connor. He's feeling saucy.
Pressure
Looks like he's gonna go.
is on.
You know, I think I'm going to end the round with a nice 1-point question.
Oh, that's boring. Yeah, any one of those. I
I
guess
know.
not this one.
No.
but
I mean, this
yeah,
is
any
that.
one of those.
This is
Are we going solo or?
all right. What?
This guy doesn't want to have fun.
I know. He's over with the fun. He's done.
Yeah.
What was
Awarding the points.
What was the order of the prompts for mock trial 2022?
You could just say it.
You could say
Okay.
yours.
Prompt 1 was a client call. Prompt 2 was a settlement conference surprise pre-hearing conference type hearing. Then we had the medical depositions of all the doctors. Then we had the trial, and now we're here today with the podcast.
That's correct. Oh, 1 pointer.
One.
Nice 15-point outing right
It's a
there.
nice foul shot for you.
All right, so we'll be right back to go over the actual substantive portion of the mock trial podcast. And we're back. So we just watched a video of the decision after trial from Judge O'Donnell in his best, I guess, fictional character / real character impersonation. You know what was interesting, Addison, is that when we watched it earlier today with the Paralegals for the first segment, they were really taking it in and trying to figure out their theories going on. As soon as we started the video here, all the attorneys just started taking notes.
Yep.
It's almost like that trial experience started kicking in. It's kind of interesting to see. So let's start there, guys. Like, what do you think that was? Like, we'll describe what that video was, for our listeners who obviously are not going to see that video. What happened there?
So basically, the case was disallowed. To elaborate, so this is usually called ANCR hearing, where parties argue as to whether the case is compensable, and if so, for which site. And here, evidently, Judge O'Donnell disallowed the case, which means unless claimant appeals and wins in the appeal, they will not be compensable for the accident.
So, what was the reasoning for disallowing the claim?
So, from what I got from it, this was the judge basically summarizing everything that was before him and in making his decision, and he found that the claim was staged based on not having a clear narrative of what exactly happened. I think that was one of the major points. It kept repeating, no clear narrative, no idea what happened, and also the claimant's story seemed to be weird and a lot of unlikely events. But he was basically giving us a reasoning why the claimant failed to meet his burden in proving that the unwitnessed accident did actually happen.
An interesting point of view, maybe from Connor here, because we weren't in attendance for it. We had your performance judged separately from the entire group. When you had your prom, you were taking testimony from the claimant, right? And it's the same claimant actor that we had at the trial, so the same types of information. When you're going through direct to the claimant, cross the claimant, did you think that this was a winning case for the claimant?
I would honestly say it was maybe a 50-50 shot. She had the medicals there, but I think what really turned it was while the witness statement was unreadable, illegible is the proper term. There were so many holes and inconsistencies that I found. When I was getting to do it, I think she testified. She was on one floor of the factory on direct, and then when I asked her, she was somewhere else. She was saying the main lobby is the 4th floor, but it wasn't the 4th floor. So she was all over the place and gave a lot of inconsistencies. And I think based off her direct, I was able to attack her more so that way.
Okay. Anything else from you guys? Like any takeaways from the video that we saw before we head into what actually will be happening based on that video?
So everyone missed 2/31/22 date on, was it on the medical record or was it on
the witness statement?
Yes, I think it was on both.
Yeah, that everyone missed 2/31/22. Now that I think of it, it's very shocking.
Right. Actually, the paralegals brought that up in their segment, right? It's like a notice defense issue, but yeah, it's true. I mean, sometimes when we do so much, it's like that little minute detail that can really change the complexion of the case. So, what happens now, for purposes of our podcast prompt, is that the claimant has appealed, as you might expect. Otherwise, we would have nothing else to talk about. But the claimant has appealed. Okay, so we're not going to assign roles or anything, but we're just going to be talking about issues, right? Conversationally, what do you guys think the claimant would argue on appeal, and what would the defense argue to rebut the appeal? So, no real layers or anything. Like whoever wants to, really start and take us through there.
I think the first thing they're definitely going to argue is the issue of notice. It seemed like Judge O'Donnell was focusing on the inconsistencies in the reporting, but what they would argue is the issue of notice, since the witness Jim Marzola was there and filled out the report and noted he was there. They'll argue there's no issue of notice because it's constructive. He was there. The witness 21 doesn't apply. So from a notice aspect, I think that's how they would attack it there.
I feel like in terms of an accident aspect, I do believe that while a claimant has some form of a memory loss, some of the documentary evidence that exists there, and also John Marzola's testimonies, and Jim Marzola's testimony and everything.
Not to be confused with managing partner John Marzola.
Yes.
Here at LOIS Law Firm.
Is actually strong enough for establishment purpose, at least. And also, I think they would argue that Judge O'Donnell's, based on his oration of judgment, he probably was not making good decision here. Like, his decision might be generally not.
I am not of sound mind.
Just not a good judge of the factual issues in this case. Probably that's
so kind of. He's kind of saying that. Yeah.
Continue, counselor.
So accident notice. What about causal relationship? Any
Well, I think it's my position that if I were the claimant and I was appealing, I would just continue my same argument, which I committed to when I make my argument. And
right, because you were in the summation.
Yeah, and that's the Section 21 presumption. I think that the claimant had all of the evidence, medical as well as testimony, and despite some inconsistencies, the carrier didn't really provide anything to refute anything that the claimant was putting forward. So he was entitled to that presumption, and I think that's going to be the basis of the argument. I would just hammer in on that. The defense obviously is going to say, well, the judge was the best. He had the best. He was in the best position to review the evidence and make a decision based on what was before him. He heard people in person. He saw the witnesses. He was in the best position to make that decision. So there's really no basis to interrupt that.
See, he was of sound mind.
Oh, there you go.
There were no errors of fact.
No errors.
Yeah, I mean, in reality, when we're talking about accident and notice, aside from the causal relationships, usually if we don't produce any employer witness, and as long as claimant doesn't look like she's outright lying or she's completely incapable of testimony, if we have documentary evidence and also claimant testifies, and usually judges just establish the case. It works almost like PFME sometimes.
Oh, like saying that, it's like a low burden for the claimant.
Yeah. For accident and notice.
To establish the case. Like, in practice, I guess that's true just based on the numbers, right? It happens more often than not. But Nathalie brought up a point of saying that the judge was in the best position to make a decision, right? So what is the defense saying, substantively to rebut the appeal? Meaning, like, what best facts or arguments are out there to say that this claim should be disallowed?
I think I would say we at least produced one witness of our own, and albeit our evidence being relatively weak compared to the claimant's evidence, we'll also just point out some discrepancies and memory loss issue, and judge considered everything, and basically he's got great deference.
I would point out just the claimant's inconsistent statement just don't make him a credible witness. So even if the judge was in the best position, to make that call, he would have seen, like, I don't believe him, and that's exactly what the judge did. He listened to the testimony, and the claimant just kept lying about different things. So
The board and the judge has the discretion to determine credibility when presented with all the facts, and that's what we would argue from the defense side, that when taking the testimony, the medical deposition all together, and the credibility cornucopia there, it would they have the final determination.
So I've got a question. All of you must answer one by one. Don't say, yeah, what he said, yeah, what she said. I want your rationale. Say the Section 21 presumptions do apply. In terms of refuting those presumptions, does the evidence need to completely rebut the presumptions? Yes or no, and explain. I'll start with you.
I would say no. I don't think it needs to necessarily rebut every presumption, but it has to be, I believe the standard is substantial evidence. So we would need to be able to present something substantial enough to refute something. Like maybe the incident report, maybe it wasn't filled out timely, but they should notice. The witness was there and said, oh, I was standing right there. There was nothing there. So there's ways to rebut it. And then we would also have to prove that we were prejudiced by the delay or anything of that nature.
Kyung Jae?
Added to that, because the substantial evidence standard is not like beyond reasonable doubt, which some of the listeners might be more aware of. It's a very flexible standard, so it would be up to the board or the law judge who's making the decision. A lot of deference would be given. And since this case was already decided at a trial court level, this judge doesn't think this accident happened, because usually in the appellate levels, they don't like reversing the decisions as long as it's arguably legally correct. And because, again, of that standard's flexibility, I think we don't have to provide the evidence that's so strong to rebut it.
I'll keep it short. It's the same, but I'll just put it in a different perspective. I think it doesn't have to be completely, doesn't have to rebut completely the evidence, but I think it has to be enough to tip the scales. The judge is in between, he's weighing the evidence, and it just has to be enough to kind of like tip a little bit.
I think it's actually a good question to ask in light of what Kyung Jae brought up about the importance of producing the witness at trial, because really the fact that claims are deemed compensable so often is seemingly like it's like a low standard. Legally, it's not. It's a pretty high standard once we just rebut the presumption that it's an unwitnessed accident, right? So if we say that it's witnessed, then we get out of all of those easy, arguments that the claimant is going to make to establish the claim, and it makes it more comprehensible to make a defense theory for the judge. I have a question too. So you guys know what the claimant would argue, and you know what the defense would argue in rebuttal, right? So given the facts of the case, would the board panel affirm or reverse Judge O'Donnell's decision, and why? So you just write it down, and then each of you guys will go one by one. Would the board panel affirm or reverse Judge O'Donnell's decision? So now, we just gotta put some banter in while they write something. Man.
Not my brother. Car Talk, NPR, Saturday mornings. That's all they did. One of my favorite parts of the entire mock trial program is the final podcast. And last year's final podcast, I was on the other side of the table, and Chris Meacher was the co-chair.
Oh, that's right.
And he's an intellectual powerhouse, because he was asking questions about loss transfer.
Right, he was always just building those questions. It's tough.
Section 29, and so better me than him this year, huh?
You're not an easy one yourself with that respondent brief deadline question. So
they'll never forget it.
Right. I think is that enough time? That's enough time.
Yep.
Right. All right. So I think Kyung Jae, you finished first. So
the
go first.
The board panel is likely to affirm the trial judge's decision because, first of all, the board panel doesn't like reversing the trial court decision to begin with most of the time, and also given that employer arguably produced enough evidence to tip the scale, as what Nathalie said before, therefore, judge's decision was legally sound, arguably. And we can think about it this way, too. The workers' comp trial judges do the work of both the juries and the judges. And in civil courts, appellate courts generally don't reverse jury decision unless there's a legal issue with it. Factual issues, they put great deference into jury unless there was some evidence that was not submitted or there was a tainted jury pool. And Judge O'Donnell doesn't seem to be a tainted jury here.
He goes from saying that you weren't of sound mind to now saying that you were.
Yeah.
Reversed on appeal.
Did anyone say that it would be reversed? Oh, you both said it. Interesting. All right.
Let's hear the rationale.
I think the board panel would like to reverse Judge O'Donnell's decision if it finds that he didn't give sufficient weight to the totality of the evidence. this case, the claimant provided medical evidence, provided evidence of that there was notice, and while the testimony is questionable, like little discrepancies here and there, I don't think that the board will find that they were sufficient to discredit that an accident occurred. The carrier didn't really bring up anything that was concrete or enough, like a heavy, type of evidence showing that the claimant was lying. I think they kind of just introduced the idea that you could question whether, one explosion, two explosions, but I don't think that the board can find it sufficient to this scale. I think on that basis alone, the claimant is going to get the presumption. The claimant's going to get it.
Okay. Well, Connor, do you have anything different to add there?
Yeah, just a little. I mean, I completely agree. I do think it would likely be reversed by the board panel. We all know the Workers' Compensation Board loves claimants to get their money and give them so much leeway with just about everything.
Not speculation.
And the issue of notice, I mean, the incident report is signed and dated and filled out within the 30 days. If the accident happened on February 2nd, 30 days would have been March 4th. It was signed on March 4th or March 1st and completed, I guess, February 30, 2022, even though that's not a real date. But still, it was within the 30-day notice. Plus, the accident was witnessed. The employer witness was there. He testified to the explosion, which kind of, in a way, corroborates the claimant's allegations of events. And then, too, you have to look at it from a medical standpoint, too, because causal relationship is the legal determination for the claimant meeting her burden of proof, and then there's also the medical aspect of causal relationship. And unfortunately, in the prompt, the carrier's psych IME conceded PTSD and depressive disorder, albeit partially like an exacerbation of a prior. I think the board would weigh heavy on that. Similarly with the ortho of the back, Dr. Habacker in the prompt also conceded because she said there's no evidence to refute that this didn't happen. And I think that will be given enough weight to where, if anything, it will be reversed and established possibly to an exacerbation of the psych condition and an orthopedic injury to the back. Now, as it relates to the inhalation, I think that will be thrown out just because there was no safety data sheet. The doctor had nothing, no toxicity reports or anything like that. So I do think when you're taking all of that into consideration, that because the board's going to take 4 to 6 months to review all this, and I think it would be reversed.
I will just add also that, in my opinion, the board might be swayed by the shock value of the incident. We're just seeing a catastrophic event.
Right.
I agree.
That's
Everyone
actually
agreed.
what
Everyone
the paralegals discussed. It was actually an interesting back and forth because the nature of the shock value of this event would lead the Workers' Compensation Board maybe to trend on the side of the claimant. But then there was discussion of, 49 people were injured and the claimant didn't produce any witnesses to say it also happened and all these injuries. That was a point of discussion where it's like, if they didn't bring these witnesses in, did this happen? You could also look at Judge O'Donnell's reasoning. He's like, if he couldn't tell the narrative, what happened, right?
But the employer witnesses did kind of corroborate the fact that this happened. I think at one point the employer said, there's a lot going on that day. There was a big commotion. We were trying to get an idea of what was going on.
Now, I do want to say this. Notwithstanding any Section 23A deficiencies, I actually believe that on appeal it would be affirmed on procedural grounds. I think it would be disallowed. Here's why. Claimants rarely have the capacity to write a good appeal.
Oh.
I'm serious.
That's
They don't know how to fill out the RB89 form correctly. And one of our greatest procedural arguments is the board cannot properly review a deficient RB89.
I've won on that several times.
Of course.
In the test.
Of course. Here at LOIS.
Attorney affirmation.
That's right. Here at LOIS, we that's a normal argument that we argue, that we affirm, that we win. So we ensure that our appeals go out perfectly, right? And so we have to have some chutzpah, we have to have some strength in order to do that. I don't know. How about you, Christian? Do you think it would be affirmed or reversed?
Yeah, I think that it could go both ways based on what Judge O'Donnell was saying about there's no narrative, right? Because like if I'm a claimant, I'm arguing the judge was just, not really considering all the facts if he's going to say that there's no narrative. There clearly was a narrative, something happened. So it's like if I can defeat that little sentence, that kind of defeat everything. Then again, that same sentence I would use from the defense perspective to say that Judge O'Donnell didn't find a narrative because the claimant didn't prove a narrative, right? So I think the case would just hinge on that sentence within the video. Because when you recorded it and I watched it for the first time, I'm doing what we're trying to do in the context of every case. What are the pressure points that we can use to exert some chaos and really change the game, right? Like use what we know to really make it into a real strategy. I think that ultimately it probably would be affirmed a little bit for Kyung Jae's point because there's a lot going on that the claimant could have done that she didn't do. But there is some credence to that. I think that maybe that goes to how well written the fact pattern was, Addison, that you did this year, because if there are differing opinions, then that means we did a good job. Absolutely. So, substantive portion over, right? Let's now just talk about feedback stuff, right? How did the program go in terms of good things, bad things? How can the program do better next year for our participants in 2023?
So, I think fact pattern and actors and everything was great. Just the rule was a little bit, because I kept getting summation or like a favorable, the easier part of the prompt, like ortho, which I know kind of back in my head, everything, even like 312 weeks, we memorize everything. But people who got death claim, who are like first year, second year associates.
Right.
So that thing should be evened out a little bit, I think.
That's probably fair.
Yeah.
I think that, with everything being randomized, it's probably the most fair we can make it, because if you're trying to distribute difficulty level of cases every single time, I feel like that exerts some human influence over it that might make it unfair on a different scale. But that's a good point. I mean,
I felt maybe we can get rid of that.
Yeah, just get rid of it.
Yeah, because the other things everyone's aware of, at least
Right.
psych or neuro, even if it's less extent than shoulder, we see every day.
But actually, to bring that up, and it's important because you and I actually did talk about this briefly in between the prompts, because you were wondering, what you would do if you got the death claim. Mm-hmm. And then I asked you what you would do. And you actually told me that you went through my list and started reading some of the stuff I was writing in my death claims. And isn't that the point?
Yes.
Isn't that the point of why we're doing these things? Like, you could have been lying. I still would have been happy. The fact that you said that to me. But that's the whole point of the process.
I really benefited from going out of my way to research topics that I normally wouldn't even touch, like inhalation. I've never done inhalation, but for that prompt, I kind of read up on it and I learned about 6-minute tests or mock tests, something I would never have known about. So
Right.
in that aspect, I think mock trial really promotes learning and being motivated to look for material that you know.
Okay.
I think overall it went well. I think everyone did well. The prompt was fun. It was challenging because, like Kyung Jae and Nathalie said, I personally have never dealt with inhalation either. I haven't dealt with a death claim, so that was something that I had to go challenge myself to learn. But I think too, maybe something that could be changed into next year is the overall vagueness that this year was. I understand that there's some struggle where you don't want people taking away from their day-to-day to prep for this, but for someone like me, this is my third year doing mock trial, So for me, I was really wanting to, try to showcase skills and try to train and help develop the younger associates or legal assistants or paralegals that were participating. So for me, I found that more challenging with it being so vague, and the teams, if you're in a team, they want to meet, and having to go through and try to be like, well, it could be this, it could be this, it could be this, we do this. It's kind of a lot, and you're throwing so much at them. So maybe if we want to keep it vague to a degree and make sure people aren't taking a month to prep and train, maybe the week of the prompt, say like that Monday, maybe the materials get given out then, you shorten, so it's not just like day of in 20 minutes. So that way, maybe someone who's older, like myself, or next year for Kyung Jae and Nathalie, they can try to bring up, the paralegals and the legal assistants, and maybe even new people that started, young attorneys that want to participate and get their feet wet and see how everyone does it.
Let me I want to address everyone. This is great. These are great suggestions and feedback. I do want to shed some light on this. Kyung Jae, my first lit claim, my first legal action plan budget here at LOIS Law Firm, first year associate, fresh out of law school, was a death claim. Nathalie, my first trial, my number one first trial was an inhalation trial. Connor, my first wrap-up policy that I had to represent, no e-case access, no facts, all vague. This is the hardest things that we do at LOIS Law Firm. They're the most technical things. And curveballs are good. I love curveballs because then in the real world, when the curveball comes, you can actually catch it instead of getting wet. And part of the flavor of this month or of this year really was, how can we teach the most complex things in the shortest amount of time? And you three rose to the top. The cream always rises to the top. A good thing can't go unnoticed for too long. You three proved that by sitting here. I wanted to get that out, and your suggestions were very helpful.
Yeah, and to Connor's point, I think not having the materials, it does disadvantage someone who is really good at prep, right? So if you're good at prep and we don't give you materials to prep, you could make the argument that someone else can kind of even the playing field is not as good as hearing prep, trial prep as you. But at the same time, if you're better on your feet, right, which is really what we do in almost every single aspect, from attorney to paralegal to legal assistant, right, whether it's answering the phone, answering a question, getting an email out the door, sending the post-hearing report out on time, getting a good appeal brief, everything is standing on your feet and trying to do things in a volume industry. I do think maybe the materials a week prior could be a good compromise, because obviously the paralegals said, that they want to be more aware of it as well. But who knows? I mean, one of you guys will be on this side next year, and you can really implement all of that going forward. So just to end on the podcast, every listener should know this is not a real case. Don't look it up. There wasn't someone that died.
No.
And all these names are, fictional. So thank you guys for, again, a great season. You guys performed very well. So for Connor Wetherington, Kyung Jae Han, Nathalie Thomas, Addison, any final words?
Well done. I'm very proud of you. You've grown over the past 5 months, 6 months, and I look forward to really pushing this seat to move you forward. Thank you.
And this is Christian Cison reminding you to defend from day one.